Let's start with the basics. The Workplace Safety and Insurance System is a no-fault insurance plan that covers workers in specified industries who are injured by their jobs. Ontario's workers' compensation system was the first in North America. It started at the time of the First World War. And like all classic no-fault systems, it involves removing these matters from the courts and putting in place an administrative law process to resolve entitlement disputes. It trades guaranteed benefit payments in exchange for reduced awards and reduced risk. And by reduced risk, I mean that all injured workers get benefits even if no one is at fault in causing their injury. And to do this, the system has to make coverage mandatory for a wide range of employers. Employers pay the premiums in the system, and their premiums are based on their payroll and their loss experience. Now, this historic trade-off of the removal of the right to sue in exchange for guaranteed benefits means that employers are not going to be sued by their workers for their injuries in the course of their employment. So it's important to remember, though, that the system is not well understood by lawyers and by courts because we rarely deal with it. It's not something that's well taught in law schools and certainly not taught in any detail at the bar admission course. So when you get a claim on your desk from a law office, you must not assume that the claimant's lawyer has looked at this and that the WSIB aspect has been ruled out. It is entirely possible for a claim to proceed all the way through trial with no one having turned their mind to the issue of whether or not the plaintiff ever had a right to sue. So what do we do at the outset of a file? Well, go back to remembering the basic principles of that trade-off. Workers in Schedule I industries who suffer injuries for which compensation benefits are available can't choose to sue their employer, and they can't choose to sue their co-workers instead of taking those WSIB benefits. They also can't choose to sue any other Schedule I employer or the workers of that Schedule I employer. So when a file lands on your desk, what you're looking for are defendants who are employers or who are workers. You're looking for plaintiffs who are workers. And thirdly, you're looking for parties who are doing something work-related when they're injured. Now, this applies to accident benefits files as well. The Statutory Accident Benefits Schedule allows insurers to elect SABs over WSIB, but they can only make that election so long as it is not just to avoid WSIB. They have to have a genuine tort claim to pursue, and obviously if no right to sue exists, then that condition is not met.